You agree? General Katyal began his argument in a fairly dramatic fashion by saying we've never, in 222 years, had a case where the damages and the relief sought were as broad as they are here. Do you have anything to rebut his proposition? Any case where it has been as broad as it is here?
Well, of course, it depends on what you call broad. There are many cases, small cases, involving an attempt to limit discharges by companies.
What's your candidate to rebut his proposition?
Well,
a broader case with respect to the infliction of damage and the need for relief.
I guess what I would say is that cases allowing suits against large contributors, with or without others, and dismissing against small and remote contributors, I'll give you 3 state cases that are cited in our briefs. A California case about a large mine that was sued for polluting a river when lots of others polluted it and were not before the court.
Well, not as many as contribute to global warming.
No, that's correct. But we could talk about, if we talk about large contributors here, then we're not talking about so many contributors. We could have it down to thousands or hundreds or tens, depending on how we define large.
One aspect of the litigation process as opposed to the agency process, agency makes a rule, and that can be challenged in court. But suppose your plaintiffs lost this case on the merits. I take it this is not a class action. There's no certification of any class. Other plaintiffs, before another district court, could launch a similar action against these very same defendants, right? There would be nothing to preclude that.
No, well, the parents' patriotic actions by the states might have some consequence for the citizens of those states. But yes, there would be others who would have the ability. Other states, I suppose. I mean, our claim here is that this federal common law nuisance is available first and foremost for the states, and the question of whether the land trusts or any other private parties could even bring it is.
Well, even if you won and the district court imposed some sort of limit, would there be any obstacle to other plaintiffs bringing suits and another district court issuing a different standard? Well,
ultimately such things would be resolved by appeal and by the circuit courts. I mean, there are conflicts in many areas. That's true about every district court litigation.
Well, no, it's not, and it's not true of every litigation in this sense, that everyone is harmed by global warming. So unless you limit your suits to the states, I'm not aware of a principled basis for doing that, every individual in the world, if they can establish jurisdiction, can bring one of these causes of action.
A principled basis to limit the federal common law of nuisance, as I said, exists principally for the states. For the reason it survived Erie was the court spoke of the strong federal interest in providing the states with a remedy for interstate pollution. So there is a principle there. And then beyond the states, plaintiffs would have to bring a common law nuisance claim, as well as to have standing, would have to have a special injury of some kind that would distinguish them from the general public. The land trusts here argue that because they hold their lands in trust, and so for the public, they have special standing. There's no need to reach that question. This case could turn and should turn on the right of the states to protect their people and their land from interstate.
But, General, much of your argument depends on this notion that this suit is really like any other pollution suit. But all those other pollution suits that you've been talking about are much more localized affairs. One factory emitting discharge into one stream. They don't involve these kinds of national, international policy issues of the kind that this case does. I mean, there's a huge gap, a chasm, between the precedents you have and this case, isn't there?
I don't know that I'd call it a chasm, but there's a large distance between them. But I'd like to separate two things. The international aspects of this are simply, I think, beyond. We're not suggesting that that the federal common law of nuisance entails relief against international defendants. It does exist for conflicts between the states, essentially. So I'd like to put those aside. And then, in terms of the magnitude, well, there are many cases, not just one factory. The Milwaukee against Illinois itself involved not just the Milwaukee sewage district that was sued, but there were many other contributors to pollution in that lake.
In setting these standards, there would be some difficult trade-offs, wouldn't there? And could you just explain in concrete terms how a district judge would deal with those? And just determining the facts is going to be hard enough. But let's assume all the facts are proven. There's not a dispute about the facts. So that if a certain reduction in greenhouse gas emissions is ordered, that will have this effect. It will increase the cost of electricity by a certain amount, and that will produce certain effects. It will result in the loss of a certain number of jobs. It will mean that consumers will have less money to spend on other things. Some people will not be able to have air conditioning in the summer. That will have health effects. How is a district judge, or what standard does a district judge have to decide those? It's just, what is it, just what's reasonable?
Well, reasonableness is the beginning. I've suggested already, first, that we've alleged that this can be done without increasing the cost to the consumers. That may seem that is a subject for proof.
Implausible is the word you're looking for.
Thank you, Justice Scalia. But a very good place to look is what other companies have been able to do or have done, including, as I suggested, in Tennessee Copper and perhaps in this area as well, companies that settle this litigation or companies that don't litigate but instead do adopt measures that haven't been widely adopted. There is a practice to examine in the world about what's feasible and what's cost-effective, and that's not different from...
Well, suppose cost-effective. Suppose your complaint is the same, but you alleged what I get from reading might be the best way to deal with the problem. I would like the court to impose a tax of $20 a ton on carbon. All right? We bring all the polluters in, and the same injury that you have, everything's the same. You have 14 experts who say this is how to get it done. It's cost-effective. It'll lead to substitution. It will actually bring about a world without global warming. And so let's do it. Now, does the district judge, in your opinion, have the power to enter that order?
I don't think so.
All right. Now, the next question is going to be, if he does not have the power to enter that order, which could be proved to be extremely effective and as least possible harm to the consumer, why does he have the power to enter the order you want?
Because the common law of nuisance is addressed to direct the polluter to abate the nuisance.
Well, this is addressed to that. It says abate the nuisance. Here's how you're going to do it. You're going to put a $20 a ton tax on carbon, and lo and behold, you will discover that nuisance will be abated. And we bring in 15 economists.
Actually, the order we're asking for is less intrusive than that. We ask the defendants to abate the nuisance. We ask the court to order them to abate the nuisance by some amount, informed by what information is available about methods.
Well, why is it less intrusive to try to get into the details of how an electricity company will, in fact, run its operation than to say all you have to do is make a change in the dollar sign